my own screen because all the participants can be seen. I don't want my screen to get a little blurred, overlapped by this. Okay. So I'm starting here. So as spoken by Ankita, today's topic is of the workshop is IBC vis-a-vis limitation law and how far applicable it is, what is the interplay, what has been the judicial pronouncement at different stages, and try to depict the whole journey that we have seen in the last 4 to 5 years or plus 5 years time that we have seen in the IBC journey so far. We are talking about initially to set the motion of the discussion or the workshop today. Let's go through basics of what limitation law is, what's the rationale of introduction of this law, what are the maxims, what has the Honorable Apex Court said about this, what are the key sections, key provisions of this particular act, and then discuss how the interplays have happened, how the judicial pronouncement have traveled in the journey of IBC. So to begin with, what do we say is the rationale of the limitation law? Of course, this is an act which was passed in 1963, last. Now, if you look at the preamble of the Limitation Act, it states that it is a consolidating act dealing with laws of limitation of suits, appeal, and certain application to the court. It revolves around the concept of fixing or prescribing a certain time period for barring legal action beyond that prescribed time period. And the rationale is to make the litigation effective. We'll read that somewhere else. To make the litigations expeditious, non-dilatory, and effective. That's what the preamble and the rationale of the Limitation Act that has been there, or that has been enacted by the legislature here. Of course, we know that this is known as the Limitation Act of 1963. Currently, it is applicable to whole of India. Of course, J&K, we will see in the next slides. It is also post 2019 amendment. It is now applicable to J&K also. And if we, to begin with the limitation, if we look at the word limitation, the meaning of term limitation itself in colloquial terms or in general terms is limitation or restriction or a rule, circumstances, etc., which is prescribed, which draws a restriction or time period boundation, which is prescribed. What has on this rationale, if you look at commentary which has been drawn from the cases by the Honorable Supreme Court, the Supreme Court of India has also held that the rules of limitation have been enacted to ensure that a person exercises its right of remedy as soon as possible and does not resort to dilatory tactics. In fact, that's a key observation. And as we saw in the rationale, that the key objective is to make litigation efficient and effective. And the Honorable Supreme Court clearly says that a litigant or a person who has a right does not resort to dilatory taxes. The Supreme Court at various instances have also clarified the interplay between Limitation Act and other statutes for the purpose of ascertaining time limits of exercising legal remedies provided under different statute. There are different statutes, different acts also have given in how many days you can file an appeal. If further appeal is to be done, what is the maximum timeline of delay that can be condoned by a particular court or a tribunal? So they have, and in various judicial pronouncement, have also clarified the interplay between those specific statutes and Limitation Act. And these have been used to drop the runtime and the limitation applicable to those statutes vis-a-vis Limitation Act. Now, quickly, of course, pardon me if I am not able to pronounce the Latin portion correctly, but just thought I wanted to add, what is the maxim for the law of limitation, the roots in the maxims? So the first one is, may I request all the participants here to put their mics on mute? I can hear some disturbances.
So I'll mute it.
Yeah. So the first one here is interest Republic C puts sin finish lithium. It means that in the interest of the state as a whole, there should be a limit to litigation. And the other one is the vigilantibus non dormintibus jura subvenient, which means the law will assist only those who are vigilant with their rights and not those who sleep upon it. Of course, many of us who go to the court, we hear this argument many a times. You can't come and keep knocking the doors of tribunal or in the court, keep mentioning when you were sleeping on your right, and now that the timeline limitation for the period is over, you just can't cry wolf in the court of law. What it says, the law of limitation specifies the statutory time frame within which a person may initiate a legal proceeding or a legal action can be brought if a suit is filed after expiry of the time period prescribed. It will be barred by limitations, which means on the grounds of limitation, the honorable courts or the tribunals, as the case may be, we have found it many times that such legal proceedings have been dismissed. Let's move. Now let's look at what are the objects and scope of the Limitation Act. The law of limitation prescribes a time period within which a right can be enforced in a court. Now, which we will see as we go on, the whole act and specifically the time period for various suits, appeals, and application has been provided in the schedule of the act. We will run through the schedule and see how it is structured in the subsequent slide. I have shared the structure of the schedule also. The main purpose for this act is to prevent litigation from being dragged on. As I said earlier, the whole ambit and the objective of is to put a restriction on the time period within which a litigation can be initiated or an appeal can be made. And to prevent litigation from being dragged on or litigants using it as a dilatory tactic. And this is important for a quick disposal of cases and which should, of course, result in effective and efficient litigation. As I said earlier, the Jammu and Kashmir Reorganization Act 2019 provision of limitation act will now apply to whole of India, which means it will apply to Jammu and Kashmir. Earlier, it used to be applicable to whole of India except state of Jammu and Kashmir. Now it is whole of India. Now, what does this act contain? It contains provision relating to computation of time for period of limitation, condonation of delay, etc. And this whole act contains 32 sections and 137 articles. The articles are encased in the schedule of the act. Now, one very important thing which has been, brought out by honorable courts in their different judicial pronouncement also. The fact is that Limitation Act is exhaustive with respect to all matters expressly dealt in it. And the key point, it cannot be extended by analogy. My friends, here, if you've read some of the Supreme Court judgments, that's what I have noted also, where the honorable judges, while pronouncing the order or in their order, have written that limitations cannot be extended by analogy. And of course, in different contexts also. Ordinarily, this act applies to civil cases except in the matters specifically provided for that purposes. So we will see and discuss what are the exceptions, what are the nuances going forward. Now let's look at the schedule, which mentions the period of limitation, etc. The schedule, the act contains 32 sections. Of course, section 32 has been repealed. However, the schedule contains 3 divisions, which deals with, first division deals with suit, second division deals with appeal, and third division deals with applications. The first division is further divided into 10 parts, and articles 1 to 113 is encased in the 10 parts. The second division deals with appeal, and article 114 to 117 are addressed there. And the third division deals with application, which is in 2 parts, and article 118 to 137 has been encased there. I'll just get off this PPT and show you the schedule, and we'll quickly run through it for generating the basic understanding. Can you see the screen?
Yes, sir.
Yeah.
So it's yeah.
Yeah. So this is a schedule, period of limitation. First division deals with suit, and then further there are parts. The first part relates to, I'm going to read some of them just to discuss what are the items covered here, what is the period that is mentioned, and when does that period, time from which the period begins to run. So first part in the first division deals with suits relating to accounts. Now let's read the very first one. For the balance due on a mutual open and current account, where there have been reciprocal demands between the parties. The period of limitation is 3 years. And how does the schedule define? The close of the year in which the last item admitted or proved is entered in the account, such year to be computed as an account. So it is the year ending in which there is a disclosure or the item is proved there. That's one of them. Now let's look at the third item. Between a principal, if a principal has to bring a suit against his agent, by a principal against his agent for movable property received by the latter and not accounted for. The time period is 3 years. And when does the time period begin? When the account is during the continuance of the agency demanded and refused, which means if there is a demand which is made by the principal against the agent, the date of demand, or if the demand has been made and later on refused, the date of refusal, 3 years would be counted from there. If not, neither of this has happened, then when the agency terminates, the right to sue will begin from the terminating date of termination of the agency, 3 years from then. So that's how it has been defined. I think it's generally very clear. One has to contextually match the case on hand with the applicability of the suit here, and then look at the second part deals with suits relating to contract, and all kind of contracts are covered. It's a large section, it's a big section, right from seaman's wages, wages in any other person, price of lodging, price of food, career for compensation for losing or injuring goods, then hire of animal, balance of money advance and payment of goods to be delivered, the prices of goods sold. And I'm just quickly running through trees or growing crops, money payable for money lent, suits like lender has given a check for the money. Then many of them plaintiff, compensation for breach of promise to do anything at a specified time, on a bond subject to a condition, on a bill of exchange or promissory note. It's a large one. It covers all complete gamut of contracts that one can come across. For ease of understanding, which I'll repeat later on also, if you see contextually, the runtime may differ depending on the specific description of the suit. But what we see is it is 3 years timeline is generally provided. Just for ease of understanding as a layman, not as a professional. As a professional, we'll have to take the case specifics of the case on hand and match with where we fall in. Then the part 3 deals with suits relating to declaration. Here also we see largely 3 years, or it's 3 years only. Part 4 deals with suits relating to decrees and instruments. Then part 5 deals with suit relating to immobile property. This is where you will see the time period change happens. And throughout the schedule, we will notice, as just for ease of understanding, I'm not trying to generalize the applicability of the schedule, just for ease of understanding, that whenever a suit, appeal or application is dealing with a property or an immobile asset, immobile property, the timelines differ, except where there is a movable asset that is to be recovered, a movable part of the asset which is to be recovered, even while the suit may pertain to an immobile property. So if you see redeem or recover possession of immobile property mortgage is 30 years, within 30 years. And when the time starts, when the right to redeem or to recover possession accrues. Similarly, 662, if you see, to enforce payment of money secured by a mortgage or otherwise charged upon immobile property, that's 12 years. And why I'm specifically mentioning this is Article 62 is widely applicable to the cases that we do under CRP or liquidation. Because most of the time, and majority of the cases, the lenders do registered charge either through an equitable mortgage or by a general registry of charge against the asset of the company, which may include immobile assets. So in case if there is a security which is created by a mortgage of immobile property, then the suit can be filed within 12 years. Of course, we will repeat this, what I'm saying, when we go to claims in IBC vis-a-vis limitation, that section. However, just for clarity, from the date of default, if an IBC case is to be brought on, a suit, or Section 7, Section 9, whichever is to be filed, has to be filed within 3 years of the default. And we will see the judicial pronouncement in that aspect where the runtime begins from the date of default. There may be a case where the date of default has been taken the date of declaration of NPA. However, largely it is date of default which is coming. So in case where a lender has got the immobile asset as a mortgage of the corporate debtor, in that case, that particular Section 7, I'm emphasizing on Section 7 because financial creditors, normally as a practice, they get the mortgage. I've rarely come across operational creditors getting a mortgage of property. Usually it's financial creditors. And in that case, they can file an application under Section 7 within 12 years of that. So similarly, it's very exhaustive. It has covered quite a few things. See, you will see what I was saying earlier. If you look at 61C, what it says to recover surplus collection received by mortgagee, which means it has got nothing to do with transfer of immobile property. But what is being addressed here is collection of mobile property, which is money in excess to the value, recover surplus collection, and we find that it is 3 years. So similarly, as we go down, we will see that most of the description of suits dealing with immobile property, repossession, filing a case, auction, anything, 12 years is a timeline within which, and a most apt article to my understanding is 62, which comes into interplay in most of the CRP cases. Now, if we go to part 6 deals with suits relating to movable property. And here, all kinds of movable assets and properties have been mentioned. Timelines also against specific, say 68 says for specific movable property lost or acquired by theft or dishonest misappropriation or conversion. And when the time period begins, when the person having the right to the possession of the property first learns in whose possession it is. So it is the time of knowledge when it comes to the person having the right of possession, 3 years. So most of the movable property in recoveries, the period of limitation is 3 years. Suits relating to torts, largely 1 year time has been given. And I think for the sake of speeding up and not taking too much of time, I'm not reading through each and every article. There are certain aspects which give you 2 years, 3 years time also. It's quite exhaustively covered. Part 8 deals with suits relating to trust and trust properties. And normally, as from experience, we would know trust and trust property deals with mostly immovable assets, etc. However, contextually, it may be different, but endowments, etc., barring that, you will see that the 12-year period related to immovable is covered here. Part 9 deals with suits relating to miscellaneous matters under the suits category. And for all miscellaneous matter, 1 year to 3 year time period has been prescribed. And of course, anything which relates to which may have a estate or immovable property, then again we see 12 years. And part 10 deals with suits for which there is no prescribed period. So it's exhaustive because it covers where there is no specific description is given and no specific period is meant. Both the things are covered here. Any suit for which no period of limitation is provided elsewhere in this schedule, 3 years is the timeline which has been given, and the time period starts to run when the right to sue accrues. Now, if you go to second division, it covers with appeal. Different legislation or acts like IBC also specifically mentions that to appeal to the appellate tribunal, 30 days time is given, and to appeal to the Honorable Apex Court, 45 days timeline is given. So barring those, this is a generalized timeline for appeals that has been given, and it's covered by 114 to 117 articles. And the last division covers applications. Part 1 covers application in specified cases and gives the timeline there, ranging from 90 days, 30 days to 90 days. And what is more important is the last part of it here. It's part 2, which deals with other application. And this is Article 137, which says any other application for which no period of limitation is provided elsewhere in this division. So we would have seen in BK and other where Honorable Apex Court has also mentioned that the limitation under 137 would apply. We will discuss those specific cases when we come to that. So this is what is a very quick snapshot of the schedule, which contains 137 articles split into 3 divisions and various parts within there. Let's go back to our discussion on the now. Another aspect which we needed to understand is whether this act has a retrospective operation or not. Now let's see, and then let's establish through different judicial pronouncements. Honorable Apex Court in the case of BK Education Services Private Limited versus Parag Gupta and Associate clarified that since the Limitation Act is a procedural in nature, it can be applied retrospectively. And to support that, in another instance, in the matter of Tirumala Chemical Limited versus Union of India. Again, the Honorable Apex Court observed that statutes of limitations are retrospective in nature so far as they apply to all legal proceedings brought after their operations or enforcing causes of action accrued earlier. There was another case in this matter, sorry. Yeah. Whereby Honorable Punjab and Haryana High Court in the matter of excise and taxation versus Frigo Glass India Private Limited ruled that it is well settled that the law of limitation is a procedural law and operate retrospectively until unless it has been provided differently in the amending statute. Therefore, we can derive or we can infer that unless there is a contrary intention manifested by express or necessary implication in the legislation itself, procedural laws generally apply retrospectively. Let's look at definitions and important provisions. First is period of limitation, section 2J, means the period of limitation prescribed for any suit, appeal, or application by the schedule. And prescribed period means the period of limitation computed in accordance with the provision of this Act. What are the basic principle of computing period of limitations, and which are we will try and understand this running through the key provisions of the Limitation Act and understanding that. So section 12 talks about exclusion of time, which means when we start computing, there are certain inclusion, there are certain exclusion. The period of run when it begins and the period is very well specified in the schedule. So the case on hand that we may have, we can first correlate it with the schedule, with the description of suit proceedings, etc., and look at the runtime, how it begins, and the period which is applicable. Beyond that, we also have to look at what are the other provisions of the Act which are applicable, which may look at exclusions. So section 12 talks about exclusion of time in legal proceedings, which includes day of judgment, the first day of the application, time for obtaining copies of order, decree, sentences, and time for obtaining the award. If that's the time, this is the timelines, or these are the number of days, period, whatever it is, can be excluded as per section 12. Section 13 is similar to section 12, except that if the application as a pauper has been made, we will see what a pauper is later. But if an application has been made as a pauper and the day of rejection, then this period shall be excluded. Section 14 clearly says that the time period where the proceeding has been going on in a court without jurisdiction, so a case has been filed into a particular court. However, that court does not have jurisdiction over the matter. In that case, that period of legal proceedings can be avoided, or it is excluded. Moving on, section 15 talks about other special causes for the exclusion of limitation period. One, where the stay by injunction or issuance of order and the day it was withdrawn. So the period during which the stay or the injunction given by court or a specific order, that period will be excluded from limitation. If there is a consent or sanction to be obtained from the government as per procedure, so the period of consent or sanction issued by the government, period as per statute, procedure, or policy, that period will be excluded. The time during which a proceeding is set aside, a sale has been prosecuted, that also is excluded under. And in case, of course, this has to be matched contextually and the facts of the case, the time during which any defendant has been absent from India, that period can also be excluded. Now, section 17 talks about limitation period in the event of a fraud or mistake. And it clearly states that the limitation period starts from the date of discovery of such fraud or mistake. Now, I've just put a case here. Bombay High Court in the case of Vidarbha Veneer Industry Limited versus Union of India stated that limitation period starts from the date of discovery, even if it is 100 years from the date of payments. So the limitation period will start when a fraud or mistake is discovered. Section 18 states that a fresh period of limitation starts if there is a written acknowledgement of any property, and section 18 is extremely important for us, where, of course, there are judicial pronouncement, which has now kind of crystallized the law when it talks about acknowledgement of dues in balance sheet. And there are a whole lot of arguments around it, but now it's more or less established. It states that a fresh period of limitation starts if there is a written acknowledgement of any property, right, or liability from a party against whom such property, right, or liability is claimed. It is based on doctrine of admission. So your annual accounts, if a debt is acknowledged, and there is a whole lot of arguments on that in courts, which has been, argued for, against, counter arguments have been given, saying that accounts or the financial statements are a compulsion by law. So no company or corporate debtor can avoid any kind of disclosure or filing of financial statements. That's mandatory under law. However, we will read this. The courts have now said, while filing of the financial statements may be compulsory, however, there is no compulsion of disclosure of specific items until unless it is evaluated by the directors of the company that there is a debt and this needs to be disclosed. There is no compulsion that one specific item needs to be disclosed. And a financial statement with director's report and auditor's report is a good admission. Section 19 of the Act states this: a fresh period of limitation starts from the time payment was made. It also states that if a payment was made on account of a debt or an interest payable just before the expiration of the period of limitation. That's important. Now, to support this, Delhi High Court in the case of Rajesh Kumar versus Premchand Jain stated that if a check was dated within the limitation period, and even though the check was dishonored later, the payment will be deemed to have been made because the check was issued or dated within the limitation period. And Honorable Apex Court in the matter of Jeevan Lal Acharya versus Rameshwar Lal Agarwal stated that in case of checks, the date of payment is considered to be the date of payment, which means the date on which the check, the date on the date mentioned on the check as the date of drawing it is considered to be the date of payment. Now let's look at section 21. 21 talks about the suit where a party is added to a suit. This is slightly different. This thing. After the proceedings are initiated, the limitation period will be considered to be starting from the date when the party is added to the suit normally. Only exception is if the court is satisfied that the addition was made due to a mistake in good faith, the limitation period will continue from the earlier date. So if a co-partner files a suit for recovery of the joint debt, other co-partners are a necessary party, and therefore section 21 will apply. However, if a karta has filed a suit, then the other co-partners are not a necessary party. So in the first example, limitation period is from the earlier date, the date of filing. In the second, where they are not a necessary respondent, and when they can be added subsequently, the date of limitation will begin from the date their proceeding have been started or they have been added as party, added to the suit.
You never know.
Excuse me. Hello.
Sir,
Some
I'm
background
muted.
noise.
Sir, I'm
Okay,
muted them. Yeah.
okay. Suddenly, I thought somebody was asking something. Now, we just revisit section 12, exclusion of time in legal proceedings. So I've tried to, work out a couple of things here, and let's carefully look at that. What not to be excluded here? While dealing with section 12, there are certain nuances in my understanding which needs to be taken care of. What not to be excluded? Time taken by the court to prepare the decree or order before an application for a copy of decree or order is made shall not be excluded. And we will see this specific thing in a case where Honorable Supreme Court disposed of this appeal. That, for example, there is a proceeding going on NCLT. Hypothetically, let's take a date of on 19th of December 2022. Honorable Judge pronounced the order in the courtroom. And the parties to that proceedings were present there, which means once the order is pronounced in a courtroom, the parties to the proceedings being present there, which means the order came to their knowledge on the same date. Now, if the order is uploaded on a different date, and if you look at NCLAT, any appeal in NCLAT, it's very clear stated that the application has to be accompanied with a certified copy of that order. If an application is made subsequent to the order upload, or means order being released, the period from the time of pronouncement till the period an application for a certified copy of the order is made cannot be excluded. And if 30 days has elapsed in between, then, in my opinion, the appeal cannot be accepted. So going by this context, as soon as the order is pronounced, within a couple of days you file for issue of a certified copy of the order. Then from the date you have filed an application till the time you get the certified copy may be excluded. But if you haven't done, it may not be. So it says necessary time taken for obtaining a copy of the degree, sentence, order, appeal from or sought to be revised or reviewed. Section 12. It says that. And what is to be excluded? The following time period has to be excluded from computing the day on which the cause of action arises. That day shall be excluded while computing the period of limitation for any suit, appeal, or application, and date from which such period is to be reckoned, and the date on which the judgment was pronounced. That period of litigation is to be excluded. Now, let's move. Let's look at section 13. What is a pauper? An indigent litigant who's permitted to sue or defend without paying costs. That's a pauper. To take benefit under section 1 needs to satisfy following requirement. There must be a leave to sue or appeal as an indigent person. The leave to sue or appeal must be in good faith, and the leave to sue or appeal has been rejected, which we earlier discussed in section 13. That period during which an application is made as a pauper and the time period by which it gets rejected. So from the date of application to the date of rejection, that time period can be excluded from the limitation. The period spent by applicant in good faith, his application for such leave to sue or appeal as an indigent person is to be excluded. Let's move to the next one. Section 14 deals with exclusion of time of proceeding bona fide in court without jurisdiction. So we have seen earlier civil proceeding time is to be excluded and how. So essential requirement is there must be another civil proceeding and the subject matter of the suit and respondent must be the same. The suit can be in a court of first instance or appeal or revision. The suit must be in good faith, and the court before which it is filed is unable to entertain it due to defect of jurisdiction. For civil proceeding, in Sheshnath Singh versus Baidyabati Shorepuli Cooperative Bank, it was decided the question before the court was whether proceeding before SARFAESI or civil proceeding under action under section 14 of the Limitation Act. The CMM or the judicial magistrate, as the case may be, exercising power under section 14 of the SARFAESI Act, functions as the civil court or executing court. So proceeding under SARFAESI Act would therefore be deemed to be civil proceeding in a court. So if that is not the right jurisdiction, just to continue with section 14, and due to defect of jurisdiction, civil proceedings, then that period can be excluded. Section 15. So We have read the headlines. We will quickly go through the explanations here. Day for which the order remains in force, the day on which order is made, and the day on which it is withdrawn. So that time period within which that will be excluded. In case where a previous consent or sanction of the government is required, days spent on obtaining the consent or sanction, day on which application to obtain such consent was made, and the day on which it was given shall be excluded. Now, in the case of proceeding for winding up of a company, the time during which the receiver or liquidator was appointed, that's a period of exclusion under Section 15. In case of a suit for possession by a purchaser at a sale in execution of degree, the time during which the proceeding to set aside sale has been prosecuted. So that is the time which will be excluded. And I said here, the time during which the defendant is absent from India and under territory outside India under the administration of the central government, which is any territory which is outside India, or he's absent from India on a case-to-case basis, that can be exclusion. Coming to Section 18, in case of Tilakram versus Nathu, Supreme Court stated that it is not essential that an admission is given in as many words as possible. Rather, if a statement in writing shows that there is an admission of liability, it will tantamount to acknowledgement. And what will constitute under Section 18 as acknowledgement? Balance sheets. Email acknowledging the debt constitute a valid and legal acknowledgement. Checks given by a debtor to pay his dues is an acknowledgement. And what's crucial is acknowledgement has to be prior to the expiration of limitation period. So if limitation period is 3 years, then any acknowledgement, if it is given before expiration of 3 years, then it's an acknowledgement, and the limitation period will be taken 3 years from the date of acknowledgement. Now let's see and discuss application, limitation, and IBC. And to begin with, we will also look at insertion of Section 238A and how does it play. So initially, the IBC code did not have any specific provision dealing with the limitation within which application may be moved, except limitation period for filing appeals before NCLAT, that was within 30 days, and Supreme Court within 45 days were provided in the code. Now, let's see what prompted and how the journey to 238A happened. In the decision of Speculum Plus Private Limited versus PTC Techno Private Limited, the Honorable Appellate Tribunal held specifically that the Limitation Act will not be applicable to proceedings under IBC. And in this case, the NCLT has rejected the application on the ground that it's beyond the period of limitation. And Honorable Appellate Tribunal upheld that. And therefore, sorry. So NCLAT said the IBC code came into effect 2016 and the limitation does not apply, which means any rejection by NCLT on the grounds of limitation is incorrect, so not sustainable. In another case, in NCLAT, Neelkant Township and Construction Private Limited versus We Urban Infrastructure Trust Limited, while rejecting the submission of appellant that the claim of respondent is time barred, The Honorable Enclat held that there's nothing on record to suggest that Limitation Act is applicable. The next aspect that I'm reading is even today applicable in spite of 238 and other pronouncements. Honorable Enclat further observed that if there is a debt which includes interest and there is default of debt and having continuous course of action, the argument that the claim of money by respondent is barred by limitation cannot be accepted. Now, this particular aspect of continuing debt is very much applicable in case of real estate companies, where a home buyer advances money and in return, he's supposed to be given delivery of a unit that he's allotted to him or her or it. And it continues to be a default till the time that is given. So that is one aspect which we'll see differently when we go and discuss the sections or the section of claims, IBC and claims. Now, the matter, Insolvency Law Committee report, which came in 2018, and based on which there was a section 238 was introduced based on this recommendation with effect from 6th of June 2018. Section 238 of the code reads, the provisions of Limitation Act 1963, within bracket 32, shall, as far as may be, I've just highlighted that or, put it in bold, apply to the proceeding or appeals before the adjudicating authority, the National Company Law Tribunal, Appellate Tribunal, the Debt Recovery Tribunal, or the Debt Recovery Appellate Tribunal, as the case may be. We will see, or if you have, many of you would have read in different pronouncement by the Honorable Apex Court, where it says, and it's given in the order also, the phrase as far as may be, and it has been used many times contextually in the orders, saying that the provisions of Limitation Act shall, as far as may be, applicable without frustrating the objectives of IBC. So this is what has been, I came across one or two orders of Honorable Apex Court where this particular phrase has been clearly used. It's saying, quoting 238, as far as possible, or as far as may be applicable without frustrating the objectives of IBC. So applicability in case of IBC is thus how interpreted. Now, whether newly introduced section 238 would be prospective or retrospective in nature, let's see what the pronouncement, judicial pronouncement. This question came to be answered in the decision rendered by Honorable Supreme Court in BK Educational Services Private Limited versus Parag Gupta and Associate. What the Honorable Apex Court held is that Limitation Act is applicable to application filed under section 7 and 9 of the code from the inception of the code, which means even though 238 became applicable from 6th of June 2018, but what it clearly sets that very clearly from the inception of the code, Article 137 of the Limitation Act gets attracted. The right to sue, therefore, accrues when a default occurs. And if default has occurred over 3 years prior to the date of filing of the application would be barred under Article 137 of the Limitation Act. Save except in those cases where, in the facts of the case, Section 5 of the Limitation Act may be applied and to condone the delay in filing such application. What Section 5 says, and in a very, very general terms, is that if the applicant, as per the requirement of Section 5, shows enough cause and genuineness for the delay, the honorable courts may condone that delay based on the justified cause and reason. So exception being that, otherwise, in this case, Supreme Court laid down the rule very clearly. Right to sue, default occurs, and if default has occurred 3 years prior to that, then the application will be barred. And while giving this decision, Honorable Appellate Tribunal had decision was overturned. So what had Honorable Appellate Tribunal said, limitation provided for admitting application, reply to Section 8 notice, time to complete, etc., held that limitation law is not applicable on IBC. And as the IBC is a complete code by itself, this was what NCLAT said, and this decision of the Appellate Tribunal was overturned by Honorable Supreme Court in the same case. So let's look at date of default and right to sue. It remained a matter of dispute what should be considered the correct date of computing the 3 years period. Now, I've quoted different cases just to give a larger bouquet for my friends here to read and refer. I'm sure they must have gone through this. The Honorable Supreme Court in the case of Gaurav Hargovind Bhai Dave versus Assets Reconstruction Company held that right to apply will arise from the date of default. That means period runs start from the date of default. Similarly, in another case, Honorable NCLAT in Jignesh Shah versus Unifin held that right to apply under the IBC will be the date from default and not from the date of enactment for IBC. This is a little bit of contradiction in terms of what we argued earlier. Of course, there has been certain different pronouncement which confuse us, and we'll have to live with it. The Honorable NCLAT in another case, Jagdish Prasad Sarda versus Allahabad, the date of default was considered the date of declaration of account as NPA, which could be different. Default and NPA dates could be different. So my take from this is that please look at specifics of case on hand and then correlate with the facts and the relevant case that you're referring, be it Supreme Court or NCLAT, and then take your call. Of course, in another case, Honorable Supreme Court has very clearly set the law in the case of Vasudev R. Bhojwani Abhyudaya Cooperative Bank Limited versus, and referring the BK Educational Services, which we discussed earlier, that when the recovery certificate is issued, that's the date of to begin the period of limitation. So once a recovery certificate is issued, the date of recovery certificate is the date when the limitation period begins. And in under IBC, if you have to file within 3 years, you have to file. If you don't file within 3 years, then it's time barred. Now, having discussed the basics of limitations and how things have, progressed in IBC from non-applicable to applicable and exceptions, retrospective versus date of default versus date of NPA. We have seen all this. And when it comes to brass tacks, RP or liquidator, the first battle or the first task on hand is the claims. How do we deal with the claims during CRP and liquidation? Let's see. Of course, different forms have been prescribed by different regulation for different types of this thing, creditors and stakeholders to file their claims. See, even though Regulation 6 of CRP says that IRP, while making public announcement, shall seek the claims from creditor not beyond 14 days. That's the regulation. And that regulation has been, watered down, rough, rodden over by consistent judicial pronouncement wherein the courts have allowed belated claims from creditors. Even in concern of liquidation, Regulation 12 of liquidation process regulation says very clearly that claims shall be within 30 days from liquidation commencement date. Again, various pronouncements have very clearly, it's a declaratory in nature, not mandatory, it's directory. So where does one draw a line in terms of timeline? Very clearly, the courts have drawn a line that in CRP, when a resolution plan is duly approved by the COC, even though many of them would say that most of the judgments say adjudicating authority, but the other recent judgments very clearly says it is the date of approval by the COC. Because except for technical reasons and non-compliance under 30 subsection 2 or any kind of a technical reason, the adjudicating authorities do not have power to overturn, reject, or not approve a resolution plan which has been duly approved by COC. Is the commercial wisdom which prevails. And I need not quote, plethora of judgments from Honorable Supreme Court where it has been repeated time and again. I mean, if I recall from Shashidhar to Swisarabans to Isar, JP, Ghanshyam Das, of course, they have dealt largely on different facts, but this particular fact of COC's commercial wisdom being supreme has been cross-referred in most of these judgments of the Honorable Supreme Court. Here I've said in case of Santosh Vasantarao Walekar versus Vijay Kumar Iyer, the NCLAT decided that all claims must be submitted to and decided by the resolution professionals so that a prospective resolution applicant knows exactly who has to be paid in order that it may then take over and run the business of the corporate debtor. In fact, if you recall, most of you in SR Steel versus Satish Gupta, Honorable Supreme Court also made an observation where it said, once a plan has been approved by COC, the claims cannot be admitted further. Otherwise, it's like a Hydra head, which will keep popping, and it's a never-ending issue. And in this and subsequent also, they very clearly said on the date when the plans are being approved, any undecided claims would remain, and once the adjudicating authority approves the plan, then everything falls. So we can conclude here that no limitation relating to age of debt, how old is debt prescribed in the regulation. There's nothing in the regulation. However, the claim during CRP should be filed before the resolution plan is approved. That's very clear. And once the resolution plan is approved, all claims stand extinguished. However, there could be peculiar situation if a claim has been filed, not accepted, or whatever, reduced, due verification, and the claimant has gone to tribunal. That means he is already filed. In that case, the tribunal will decide what is to be done, irrespective whether it decides after the approval of the plan or before. The fate of that claim will be decided by the adjudicating authority, and it has to be accommodated or taken by the RP or subsequent monitoring committee in CRP as per the decision of the Honorable Tribunal. In case of Ghanshyam Mishra versus versus Edelweiss ARC and others, Honorable Supreme Court held that once a resolution plan is duly approved by adjudicating authority under Section 31, the claims as provided resolution plan shall stand frozen and will be binding on creditor, including statutory authorities, employees, and guarantors, everybody. On the date of approval of the resolution plan, all such claims are not part of a resolution plan shall stand extinguished, and no person will be entitled to initiate or continue any proceeding respect to a claim which is not part of the resolution plan. Similar, this thing has been reiterated. The ratio in case of Edelweiss Asset Reconstruction Company versus this is NCLT's judgment, and most of, to my knowledge, most of our practicing friends started adopting the pronouncement here that rejection of claim on the ground of delay is not sustainable because there are precedent for condoning delay. Therefore, the claims of applicant shall be considered without rejecting them on the ground of delay. Once this judgment was given by, I think, Principal Bench of New Delhi, then most of us practitioners, kind of change gear and started. Earlier, we would restricted maximum to 90 days, and after that, we have started accepting most of the claims because you reject it, the claimant goes to NCLT, and since there is a precedent, NCLT would simply throw it back. I think this was Mr. Kumar's, M. Kumar's. He was heading the principal bench, and it was his judgment. Say, what if the debt loan advance to corporate debtor is beyond 3 years period? Should the liquidator RP reject the same? Now, the dichotomy or the issue that comes to us is there's nothing in the regulation which stops a liquidator or RP from entertaining a claim within which is older than 3 years period. And in fact, most of the time, a claim which is verifiable is accepted. And it is seen in most cases, what we see is, of course, one may be constrained to verify in case no books, records, or agreements have been, given to the RP or the liquidator by the promoters of the company. That's not available. Then the issue of verification of claims vis-a-vis any of these would come. However, If there are books, and we have seen this in most cases, loans advanced to a company are generally more than 3 years old. However, the said loans or the monies given are reflected in the books of corporate debtor. So if you look at the audit statement, they're reflected. So going by what we saw in earlier judicial pronouncements, so any entry in the books of accounts showing that this particular debt is there and it's recorded in the financial statement is an acknowledgement. So based on that, one has to take it. So the claims, even if they're older, may be given in 2011 and CRP started in 2020. However, the balance sheet which has been given to you 1920, whichever the earliest balance sheet or latest balance sheet that has been shared, audited balance sheet, and it shows that this particular loan is still showing part, full, whatever, it's being shown as liability, then it's an admission of debt. That claim has to be taken. The quantum of claim to be admitted obviously will be restricted to the terms of the agreement and what has been repaid or what is the exact outstanding in the books. What is the correct verifiable outstanding? So the natural corollary to this is if the loan debt is acknowledged by the company liquidation, the liquidator is obliged to accept the claim of such claimants. The long and short is this. So verification process, the books and matching of that is important. And the judgments that we have seen in the judicial pronouncement that we came across, these help us in forming the claims so that we do not make mistakes, and that adds to unnecessary litigation on the corporate debtor or the company or entity, which we are handling as RP, liquidator, whatever. So what we say here is, as per regulation 23, the liquidator may call for other evidences, clarification from a claimant as he deems fit for substantiating a whole or part of the claim. Now, what I spoke earlier, in CRP, home buyer claims are accepted, notwithstanding the claims are within 3 years or not. As it is understood, if the unit is not delivered to an allottee, the default by the company is continuing in nature. However, it remains still a gray area where no regulation stipulates how old a debt can be claimed during CRP liquidation. However, in principle, if a debt is not reflected in the books of corporate debtor and is older by more than 3 years, it may be rejected. So the sum of all this on the claims part is here. That either a RP, IRP or liquidator, you have every right to call for evidences, clarification, additional documents, whatever you deem fit for substantiation or verification of the whole or part of the claim. While the BK this thing, I already said that the home bias is an exception, and I have personally encountered this. If two home buyers go, you reject them on grounds of, limitation 3-year-old, the court is going to howl you, because this principle is now come to be an underlying principle and widely used, that home buyer's claim is supposed to be a continuing default one. So you admit till the time a plan approval happens, till the time all home buyer claims are admitted. And of course, you have the same right under the regulation, even in CRP regulation, you can call for evidence, clarifications, anything. additional document from the home buyer to be able to decide the quantum of claim. Can we take a 5 minutes break, Ankita?
Sir, I have a question here from
Yes.
Chennai. I'm Ramchandran. Can I ask
Yes, sir.
now or after?
Yes, so one
See-
question we can take and then take a
Yeah.
break. Yeah,
Thank
please.
you, sir. See, I am handling a liquidation assignment wherein
Mhm.
we got cases of encashment of bank guarantees as early as 2010 onwards. Whereas those who encash the bank guarantees, they are supposed to be holding this encashment proceeds in the capacity as a trustee, rather without even showing any of these encashments in their books of account as contingent assets, nor setting up an adjudication by way of an arbitration. They have just been appropriated the whole sums all along. So now I came in the scene only by 2020. During 2020, they again submitted their claims, saying that they have a claim of around 450 crores in the company. So when we asked them, what about our adjudication of your responsibility of adjudicating a arbitration tribunal? They say that it has not been taken up by your side. Therefore, the question does not arise. As per my little understanding of law, anybody who was privileged with a bank guarantee in such kind of encashment proceeds, they are also cast upon with a duty to make sure that arbitration tribunal is set up in quick, double reasonable time, so that this tribunal goes into it, because they cannot be sitting on a judgment on their own costs. So now, without doing that, they have just encashed the bank guarantee of a sum of nearly 200 crores, and they are just sitting pretty at that. And for all this, this is a Government of India undertaking company. Is there any remedy for us, sir?
Now, when was this encashment made? Before initiation of CRP or after initiation of CRP?
Well, before initiation of CRP. CRP was initiated only in 2017.
And by encashment of bank guarantees, were they able to recover their complete dues?
They say that they still about 450 crores of dues payable to them.
No, in absence of arbitral tribunal, there's nothing we can do on that aspect, because that's a government system when and how and where they will establish these tribunals and things like that. So I can't comment on that. But what appears to me is, if they have encashed before CRP, there's nothing much we can do. If they had encashed it during CRP, then we could file an application in NCLT and ask them to deposit that amount. Very
I have
clearly.
another case, sir, where they have encashed. I understood. I got your point. So we got very little to do, because 2017 was the date of admission under CRP. This encashment took place in 2010, 2011, 6 years well before even the IBC laws were formed. Here I have another instance where another corporate debtor encashed a bank guarantee of 170 crores. This was a bank guarantee issued in the year 2009 for a commencement of a power project. Whereas this bank guarantee was issued only for a period of 4 years to start with. And they have clearly given a completion certificate viable for commercial operations within 4 years period. They just requested for an extension by 1 year initially, and then they entered into another agreement in 2015. So after 2015, this particular encashment, fresh agreement was not brought to the notice of the underwriter, banker. Again, they went on going with every year extension for some flimsy reasons. And by 2021, they went on to encash the bank guarantee, which is the period when I was the company was under the liquidation process. Is still under the liquidation process. Is there anything that we can do, sir, for getting? They signed for arbitration. They also nominated their arbitrator. But however, at one point of time, they said that this particular arbitration tribunal is not having the jurisdiction to try this matter, because they got a state arbitration tribunal.
So one has to look at it where in liquidation, if this guarantee was not part of the liquidation state, that we can't do anything. But if it was part of a state, then you could always file an application. I mean, I'm not well aware of the facts, but what prima facie comes to my mind. I think one needs to review this carefully, because any security interest, if it has been surrendered or if it has been, not surrendered under 52, where they want to realize, then you can't do anything, because they will realize the security interest. Of course, they owe you the whatever is the liquidation cost proportionate, and any excess realization that is supposed to come back to the liquidation estate. In case if they have not, they have not exercised the right under 52, then you can, you have a cause of action. That's what my very peripheral understanding.
This was an ongoing project. And you can imagine in 2009, this bank guarantee was issued for as part of it, 20% or 18% as a margin. For a 995 crores project, 170 crores was a bank guarantee issued. And the situation cannot remain the same from 2009 to 2021. The bank guarantees were actually encashed in 2021. So after full 12 years, when the encashment itself is a big doubtful thing. How do we...
the bank guarantee was valid, no? If they have encashed, the bank guarantee definitely was valid. Otherwise, the bank wouldn't have honored it.
But what we say is it's a fraudulent extension. Every year they keep extending. The things cannot remain the same. At stake was a 995 crores project, which was secured by this.
Very simple thing. All the extension, was it done willingly by the corporate debtor, which means it was the extension.
Only the between the two, the client and the corporate debtor. Only these two are playing. The client will enable the corporate debtor by
extension. See, only during the period of CRP that the RP gets the authority to act on all these agreements. But if it has been done earlier to that, and you find it fraudulent, you have evidence and file an application to restore this. If you find it is a fraud which has been played, then 66, 43, 49, whatever is applicable can be filed. Otherwise, you can't challenge the agreement which has been voluntarily signed by the corporate debtor. And in case of extension of bank guarantee, which means the older bank guarantee would have been surrendered and the new one would have been issued, or the corporate debtor would have gone back to the bank for extension of that bank guarantee and then submitted it to the holder of that bank guarantee.
My point here is very simple. 2009, when the bank guarantees were issued as a collateral for this ongoing project, about to be commenced project, and in 2021, when they actually encashed the bank guarantee, the situation cannot be the same. I understand from 2013 onward that project has been a commercial.
I'm not disputing that. All I'm saying is, even if a completion certificate was issued and then further extended, the contract between the parties was voluntarily signed, no? Extension was also agreed.
Extension agreed, but without the consent of the underwriter. The consent of the underwriter is to be there, isn't it? That bank guarantee is not a perpetual instrument where they can just
I understand. Then how did it get extended? Because the bank guarantee.
This work pending, and we are mutually agreeable. Therefore, they extended.
So then you must talk to a lawyer whether. But how did it get honored? If there was not consent and it was a defective instrument, how did it get invoked and got paid?
That is a trouble with the PSU bankers. See, I asked them a very simple question. For a 10,000 rupees of insurance claim settlement, don't the insurance underwriters ask you several questions? And you imagine a sum of 170 crores, and just because they invoked it and I'm objecting to it, the work underlying work is hardly 6 crores. A disproportionate amount of 170 crores is already lying with them. When I'm disputing it.
Fair enough. From the very tip of the things that I understand, if permission of underwriter was not taken, or there are issues in relation to document and then feel PSU has wrongly, then you have to evaluate, see the angle of fraud. If that it can be proven as fraud, then you can make an application.
Which is what we are doing. Which is what we are doing. First, we are asking for a restoration of the bank guarantee amount to the account of the liquidator. Because
Mhm.
after constitution of the arbitration tribunal, they were quick to point out that state arbitration is even more powerful. They have full powers to set aside your order, whatever your findings are. So we can't understand when they were the same
No,
party
no, no.
who nominated their
No, no.
arbitrator after the Supreme Court judge.
During CRP, all proceedings, first of all, CRP or liquidation, there is a moratorium. So no proceeding against the corporate debtor or any of the instrument issued by the corporate debtor as a guarantee or anything can't be. No proceeding can
But
be initiated and continued.
sir, but unfortunately, this bank guarantee is a separate contract, is what the present regime rules. They say that these bank guarantees, once it has already been there in place, they are governed by a separate contract, and when the contract is already been given for failure to fulfill your obligation, they are free to encash the bank guarantee. All
Yeah,
right,
it says because the bank guarantees were not accepted as a claim from the banker, in spite of the it being irrevocable in some sense.
they have submitted. They have submitted
So
upon
the
crystallization is what they say.
fraud angle is the only angle. I don't think invocation during this period also can be challenged. That's my limited understanding from the what I've heard from you.
So fraud angle is the only hope.
That's what comes to my mind with whatever little I've understood from you. That's the only thing that comes to my mind. Otherwise, if it is during the period of liquidation or during the period of CRP, then you can, on the ground of seizure of or you're taking away or distribution of asset of the company during CRP, that's not possible because no distribution of asset can happen without the COC's this thing during CRP. So that also can be challenged. I mean, you can look at based on the date on which it has been done.
And I
My
have a few
limited
more questions.
understanding, because we will come to that. Can I take a break? I just need
Very
to
sure.
rest for 5 minutes.
Yes,
So-
sir. We'll take a break for 5 minutes.
So 4:45, can we reassemble back?
4:45
Sorry.
we'll resume. Yes, sir.
Yeah,
Yeah.
yeah. Thank you.
Thank you.
Can we start?
Yes, sir, we can start.
Okay. So now let's move to the judicial pronouncement section. And my effort has been to list as many relevant and important judgment. In my opinion, there could be certain judgments I may have left out. Could be any reasons. Maybe I looked at it and found it important points covered under some other, covered under some other pronouncement, or maybe I haven't looked at it. So this is, in my opinion, I would add that qualification to this section. And this is some of the key NCLAT and CLT decisions that we've taken in the beginning, and then we have moved on to some of the key. The first one that I've listed down here is State Bank of India versus Krishidhan Seeds Private Limited. This was an NCLAT judgment which held that there cannot be two defaults in respect of the same debt, one for the purpose of claim filed before the debt recovery tribunal, and the other for purpose of INB code based on OTS proposal. More so, when an application filed before the adjudicating authority in prescribed format and the date of default has unambiguously been reflected beyond 3 years of occurrence of default, such an application is hopelessly time barred and shall not be punishable. This matter went to Supreme Court also, and we will see the details of the judgment when we come to it. The second one is Sri Rajendra Narottam Das Seth and another versus Chandra Prakash Jain and another. This judgment was Honorable NCLAT's 18/12/2020. It was reiterated by the Honorable NCLAT, the Section 19 of the Limitation Act is not subject to any such exception that after account is declared NPA, if the debtor makes payment on account of debt, this section would not be applicable. This would not merely be repayment, but also acknowledgement. So the key point here is that date of default could be the start of the run period. Date of NPA could be 90 days beyond that or 6 months beyond that, depending on how it is there and bank's discretion to declare the NPA. But any payment made on account of debt subsequent to it becoming NPA is an acknowledgement, provided what we saw there earlier under Section 19, that it is paid within the limitation period. So if a payment has been made subsequent to declaration of NPA, however, within the limitation period, then it's an acknowledgement, and a fresh limitation would start from the date of repayment or the payment which acts as an acknowledgement. Nirman Private Limited versus IFCI. This is another NCLAT judgment. Sued for recovery based upon a cause of action, even if it is within limitation, it cannot in any manner impact the separate and independent remedy of a winding up proceeding. I'm just reading it and then try and explain wherever necessary. A suit for recovery is a separate and independent proceeding distinct from remedy of winding up, and therefore the period spent while pursuing SARFAESI proceeding cannot extend the period of limitation, as the intent of the court is not to give a new lease of life to the debt which is already time barred. So very clearly, if a recovery proceeding is undertaken in SARFAESI, it's a civil proceeding. We have seen that earlier also. There is a judicial pronouncement to that I've quoted. However, what was clear that we read in earlier section 18, 19 and others 21, that a civil proceeding is a requirement. However, it should have been defective jurisdiction, which means the application should have been rejected for defect in jurisdiction. Here, if SARFAESI action has been pursued and then subsequently it goes into winding up, the time spent on SARFAESI, which is a right jurisdiction for recovery suits, action under SARFAESI, that time cannot be excluded. That's the primary contention that is there. Let's look at the other one, Mr. Thomas George versus Union of India. The Honorable Enclad in this said matter upheld the rationale that Section 7 proceeding under INB are not time barred, wherein SARFAESI proceeding has been initiated at an early occasion, and keeping in view the provision of Section 14 of Limitation Act. Here, it is slightly different. What it says is, keeping the view of provision of Section 14 of the Limitation Act, the same shall be considered while calculating the period of limitation. Now, any proceeding, once a CRP application is made, of course, the moratorium, sorry, just give me a minute. Correct. Here, so it is saying, I'll just repeat, just to avoid confusion. The Enclad in the said matter upheld the rationale that Section 7 proceeding under the IBC are not time bar, wherein SARFAESI proceeding has been initiated at an early occasion and keeping in view of the Section 14 of the Limitation Act. The same shall be considered while calculating the period of limitation. So here it's saying, please consider. Let's move on and see later on what gets affirmed, because during 2020, we have Enclad order which says the Limitation Act does not apply. Some orders have said that it applies in this particular scenario. So let's look at one or two more orders and then draw the conclusion. Hussain Qadri versus Edelweiss Asset Reconstruction Company. Acknowledgement in writing before expiry of the period of limitation by corporate debtor through a series of written communication in the form of letters, settlement, proposal, settlement, agreement, and payment made in pursuance thereof extends the limitation, as each of these has the effect of giving a fresh lease of life to the liability with fresh period of limitation commencing from such acknowledgement in writing having been made within limitation period. I think this one is pretty clear, where the earlier one, what we saw, that if an admission has been made, an acknowledgement is there, which is prior to the expiry of the limitation period, then that from that day, the limitation period starts afresh. MCC Concrete versus Northwest Spaces Limited. In this instant case, Honorable NCLAT held that period of limitation starts from the last date of payment, which is also shown as the ledger account, wherein only part payment was made by the CD after repeated notices by the OC, an application under Section 9 of IBC Code before the adjudicating authority for initiation of CRP that was made, which was consequently challenged on limitation. Honorable NCLAT held that the ledger account is a running account and the date of last payment will be considered the date of acknowledgement, within 3 years of which the application must be filed, as is done in the instant case. The same acknowledgement, as long as it is given within the limitation expiry of the limitation period. Entry in the ledger of corporate debtor also is an acknowledgement, and last date of payment has been entered there. So from date of that entry, the 3 years period is counted. Another case, Vijay Sitaram, Dandanayak versus Punjab National Bank. Honorable NCLAT, in light of cantenna of judgments restated in this matter, discuss in length the scope and objective of the code in regard to Limitation Act, and mention that if a petition is found to be time barred, then Section 238 of the code will not give a fresh lease of life to the time barred petition. Reiterating the point, because 238 clearly says as far as may be. However, just because it says as far as may be, it cannot give a fresh lease of life to already time barred suits of time barred applications. Kishan Lal Lakshmi Chand Bothra versus Canara Bank. In this case, Honorable NCLAT held that Section 18 of Limitation Act is applicable to proceeding under Insolvency and Bankruptcy Code. And if there is an acknowledgement of debt in the balance sheet or OTS proposal, the period of limitation would get extended if such acknowledgement is made before the period of limitation expires. With regard to limitation, earlier the tribunal took reference of a judgment delivered by the apex court in Sesnath Singh and another versus Baidyavati, Saroli Cooperative Bank, and a couple of others, wherein the Honorable Supreme Court considered entries in books of account, balance sheet, and observed that entries in such record may amount to acknowledgement of debt. So whatever we have discussed earlier, this case is a reiteration. Of course, the facts of case would be slightly different, but it, long and short, it says that acknowledgement of debt in balance sheet or an OTS proposal, which is there, that itself in itself is an acknowledgement. And that acknowledgement gets a fresh lease of life as far as the limitation period is concerned. So I think this one is a repetition. I'll skip this. Now let's look at this case of Asset Reconstruction Company India Limited versus Bishal Jaiswal and another. So this was considered to be a landmark judgment. And in this judgment, what we have seen earlier also got reiterated and become a law. See, the Honorable Supreme Court had overturned a 5-judge bench order of NCLAT in V. Padmakumar versus Stress Asset Stabilization Fund and held that balance sheet entries can amount to acknowledgement of debt under Section 18. This was the key judgment, which laid, because earlier NCLAT in the same case dealt with the aspect of acknowledgement of liability made in writing by way of an acknowledgement of debt in the books of account or balance sheet by the corporate debtor, and held that neither an acknowledgement in a balance sheet nor a decree would extend the period of limitation to institute proceeding under IBC against the debtor. However, so this was a judgment which is given, and this particular, in this case, Apex Court, when all these cases were clubbed, so in case of Bishal Jaiswal and another versus Asset Reconstruction, the judgment of NCLAT was overturned. And then on, it's a common practice if an audited balance sheet is there and that has entries, acknowledges the debt, or there is a OTS proposal, so that it is considered to be an admission, and the period of limitation as per Section 18 of Limitation Act would run from that period. There are other decisions, various other decisions, which have held that an entry made in the books of account, including the balance sheet, can amount to an acknowledgement of liability within the meaning of Section 18 of the Limitation Act. So I've just, instead of just repetitive, judgment, these are some of the cases: Mahavir Cold Storage versus CIT, AV Murthy versus BS Nagabasavana, S. Natarajan versus Samadharman. These are a couple of cases I've listed out where it is clearly pronounced that an entry made in the books of account, including balance sheet, can amount to an acknowledgement of liability within the meaning of Section 18 of the Limitation Act. Let's see what is there. I mean, there's only one part. The INB Code was enacted to consolidate and reorganize insolvency law in the country with an aim to maximize the value of asset under resolution and to balance the interest of the state. It was also intended to be a complete code, yet it did not have limitation provision in its original text, apart from Section 60 and 179 that merely excluded the duration of moratorium ordered from the composition of computation of. Initially, several benches of NCLT opined that the Limitation Act applied to IBC proceeding as its application had not been expressly excluded. Contrastingly, I'm just running through the sequence. NCLAT held that court was a self-contained law, a complete code, and hence Limitation Act could not be applied unless its application was expressly included. Although it allowed the time-barred debts to be adjudicated. It further held that the application must substantiate the cause of delay. Stale claims normally should not be entertained unless they reasonably explain the cause of delay. That was the. Of course, consequently, on the recommendation of the law committee, which is made in March 2018, the code, the government amended IBC and added 238A to make Limitation Act applicable to IBC. Now, the basic principles of the code requires that for an application to be filed under, there must exist a debt and default in payment of such debt. How the main question here is, how old can the event of default be? Did the code give a window of redemption to such creditors who have been sleeping over their rights all along? Generally, the right to sue accrues when the default has occurred, and such default has occurred not beyond 3 years from the filing of the application. So now with 38, let's look at some of the cases where the determination of period has happened very clearly. Bishop Biraja Paul and others versus Edelweiss Asset Reconstruction Company. The NCLAT in this matter held that where a valid mortgage has been entered into, the period of limitation shall be determined in light of Article 62. I think we spoke about while quickly referring to the schedule. That Article 62 would be one of the key ones which will apply to CRP and liquidation cases, which provides an application for enforcing payment of money secured by a mortgage or otherwise charge upon immovable property shall be subject to a limitation period of 12 years. And what I write is, hence it can be drawn in cases where a sum payable is secured by an instrument, the period of limitation shall be equivalent to the period prescribed for such instrument. I'll just repeat that. So we are looking at a security, and security is made via an instrument professing that security. So we can safely draw that whatever instrument that is made for that security, we can look at the corresponding description of suit in the schedule and generally and safely adhere to the time period which is allowed for that kind of a security or for that instrument. So here in this case, it's a mortgage. So mortgage of immovable property, we have seen under 62 that a 12-year period is the limitation period. Similarly, if security is created by any other instrument for which the period of limitation is 3 years, in that case, that security application has to be, in that case, the period of limitation would be 3 years. So that's where I have tried to make it a little more of generalization. And it can be drawn that cases where some payable is secured by an instrument, the period of limitation shall be equivalent to the period prescribed for such instrument. What happens? So what is the status of application filed under IBC in view of a pending application before other court? The case question here is Sangvi Movers Limited versus Tech Sharp Engineers Private Limited. Surfacio winding up petition pending. Considering that the Insolvency and Bankruptcy Code came into effect only in 2016, but the payment default had been indispensable in the economy, it was obvious that there were pending recovery suits before the court. Consequently, when IBC commenced, many pending cases were filed afresh before the NCLT. So therefore, while adjudging the question of limitation in such cases, Honorable Enclat held that where a winding up petition due to non-payment date is pending finality before a court, and meanwhile an application under IBC is filed, it is implied that there is a continuous course of action. Hence, the claim is within the period of limitation. So what we are saying, the winding up and IBC proceeding have been held to be in continuation. And because of the continuation issue, the application will be considered to be within limitation, within the period of limitation. This is a very clear cut, this thing done. What happens in case of BIFR matter? Is exclusion of period for which a corporate debtor was classified as sick unit under the SICA. The case here is Mr. Gauri Prasad Goenka versus Punjab National Bank and others. Now, in this case, relying on the principle that the period shall not be included for the purpose of determination of limitation period, if during such period a stay interim order passed by an authority is operative. That's one of the principles that's there in the provisions of Limitation Act. So the Honorable Enclat held that it so happens that pursuant to an order of BFR under SICA, a creditor was unable to take any action against his debtor until introduction of the code. So the period during which such creditor was barred by the order of BFR shall be excluded for the purpose of determining limitation. So if there is a BFR order under SICA on a corporate debtor, and it continues for whatever period, then that period will not be considered. So if default has happened before the order under SICA, then the period up to the date of SICA order, order under SICA, and the date when it is lifted, that in between period will not be counted as period of limitation. The period earlier to that and period subsequent to that will become the period to be counted within the limitation period. And if an application is filed within the applicable limitation period, taking these two periods of earlier to order under SICA and subsequent to vacation of that order will be treated, these two periods only will get computed for finding out the period of limitation applicable to this case. And then the application is filed within 3 years, if 3 years the applicable period, and 3 years has not elapsed, adding these two blocks of time, then that application is within the limitation period. I think I have already discussed this. And let's see some of the key things here even though this case is there, but the observations here may be worth noting. What are the observations of the court? In this case of Asset Reconstruction Company Limited versus Bishal Jaiswal. We have discussed this earlier under NCLAT thing and then subsequent quick snippet of the Honorable Supreme Court judgment. But I'm listing this again sequentially to understand the observations that were made under this particular case. So the court observed the rationale for introducing Section 238 of IBC is to make limitation act applicable to proceeding under IBC within inverted comma as far as may be. There is no reason to exclude Section 18 of the Limitation Act from being applicable to the IBC, provided that the acknowledgement of debt is made before expiry of limitation. Intention of acknowledging the debt is irrelevant as long as acknowledgement establishes dual relationship between debtor and the creditor. While the filing of a balance sheet is under compulsion of law, making any particular admission of debt in the balance sheet is not. Of course, the balance sheet must have been adopted. By adoption is that it should have been first adopted in a board meeting and then approved in a shareholders meeting. And it should be, after due approval, accompanied by a balance director's report, which means duly audited and filed. To file with MCA, and all of you know this, I'm just repeating contextually that a balance sheet which is to be filed with has to be audited, taken on record by the board, signed by 2 directors, and then adopted in the AGM or EGM shareholders meeting. Only subsequent to that, the whole of balance sheet or financial statements, I would use the word financial statements because balance sheet is only part of it. So profit and loss, balance sheet, cash flows, along with auditor's report and director's report is then filed with the MCA. So that's this part where the speaking order or the order of the Honorable Court has very, very clear-cut observation. I thought I'll just share this. Another one is Lakshmi Pant Surana versus Union of India. What has happened here, the acknowledgement by the principal borrower as well as the corporate guarantor after NPA date was recognized by NCLT and NCLAT. The appellant here tried to persuade by arguing that the intention behind communication sent to FC was a tribal matter. And the court rejected the argument. It reaffirmed that fresh period of limitation was required to be computed from the date of acknowledgement of debt by principal borrower. Hence, the application was within limit. However, the acknowledgement by the principal borrower as well as corporate guarantor, even though given after NPA date, was within the earlier applicable limitation period. A quick one, Manish Kumar versus Union of India. In this, a challenge was made to various sections, including Section 7. The Honorable Court reiterated the decision on limitation given in BK Educational. reaffirmed that the new law of limitation providing a longer period cannot revive a dead remedy, nor can it suddenly extinguish vested right of action by providing for a shorter period of limitation. So whatever, I think this is Quad 238A, and the challenge was made with saying, with respect to that, so the court said, if there is an amendment that, cannot provide a longer period of this thing because it's not specifically mentioned there, and it cannot extinguish. So the limitation, whatever is the original periods, would remain. Now let's look at another important decision given by Honorable Supreme Court, V. Nagarajan versus SKS Ispat and Power Limited, Civil Appeal number so and so. So what are the issues which were decided in this order? One, the questions that the Honorable Court asked: when will the clock for calculating the limitation period run for proceeding under IBC? And two, is the annexation of a certified copy mandatory for an appeal to the NCLAT against an order passed under the IBC? These were the two issues based on which the decision to accept the appeal or to dismiss it or dispose it was to be taken. Issue one, I'm just also some detailed observation and interpretation is what I have listed down. It may not be very clear for everybody to read. I hope people can read, but anyway. Issue one, what it says, the order says that Section 61(1) and 2 of the IBC consciously omit the requirement of limitation being computed from when the order is made available to the aggrieved party, in contradiction to Section 421 of the Companies Act. So, in the Companies Act, it says when the order is made available to the aggrieved party, that is missing in 61 and 60. And then the observation is that it's conscious. And owing to the special nature of ABC, the aggrieved party is expected to exercise due diligence and apply for a certified copy upon pronouncement of the order it seeks to assail, in consonance with the requirement of Rule 20(2) of the NCLAT rule. NCLAT rule says that an application has to be filed with a certified copy of order. So in this case, the order was pronounced on a particular date, and it took a bit of time for the order to be uploaded. The order was uploaded with the incorrect judicial member's name, and then, then the corrected order came after a few days. And this happened during the period, I think, 12th March to 15th and 23rd of March 2020. And the parties went on to challenge somewhere in May, June, after the initial lockdown period. However, there was no attempt made to file for a issue of certified copy. Assuming suo motu decision of the Honorable Court for the lockdown period, that's the background. And that's where the observation of the court is coming in the first section that I've read. If you look at B, what it observes, Section 12(2) of the Limitation Act allows for an exclusion of time requisite for obtaining a copy of the decree or order appeal against. It is not open to a person aggrieved by an order under IBC to await the receipt of a free certified copy under Section 423 of 420 subsection 3 of Companies Act, read with Rule 50 of NCLT, and prevent limitation from running. Accepting such a construction will upset the timely framework or IBC. And what it says is litigant has to file its appeal within 30 days, which can be extended up to a period of 15 days and no more upon showing sufficient cause. And since the application was made, there was not enough cause showing that an application for a certified copy was made and the copy was later given. We have seen earlier in our discussion that the period from pronouncement to the date of order will not be excluded until unless an application is made for issue of a certified copy. Then the period from the date of making that application till such order is handed over or delivered to the applicant may get exempted or excluded. So in this case, it was very clearly said that litigant has to file its appeal because there is not enough cost shown. I'm just reading that. Rule 22.2 of the NCLAT rule mandates the certified copy being annexed to an appeal, which continues to bind litigant under IBC. While it is true that tribunal and even this court may choose to exempt party from compliance with this procedural requirement in the interest of substantial justice, as reiterated in Rule 14 of the NCLAT rule, the discretionary, I repeat, the discretionary waiver does not act as an automatic exception where litigant makes no effort to pursue a timely resolution of their grievance. Even though the court have a discretionary power to do the waiver, what it clearly says that it does not tantamount to an automatic exception where litigants do not make any effort and assume it will be given. And what it says, appellant having failed to apply for a certified copy rendered the appeal filed before the NCLAT as clearly barred by limitation. This was the Honorable Supreme Court's judgment, and then the appeal was dismissed. So we have seen earlier, and then the State Bank of India versus Krishi Darshan Seed. This is the Supreme Court's judgment. What it says is the provisions of Section 18 of the Limitation Act are not alien to and are applicable to proceeding under IBC. And reaffirms that acknowledgement in the balance sheet without a qualification can furnish a legitimate basis for determining as to whether the period of limitation would stand extended so long as the acknowledgement was within a period of 3 years from the original date of default. And I'll quickly bring this to my own conclusion. You may agree with me, you may not agree with me, but there's my own this thing. So the limitation issues vis-a-vis the insolvency and bankruptcy code have experienced several shifts in the 5 years of the code. Of course, now towards the later part, the shifts have been largely towards concretization of some of the issues, while Honorable Apex Court's judgments, and of course, with period of time, you have more judicial pronouncement, which kind of settle the law. From non-existence of limitation under IBC to clearing the air of doubt on provision of Section 238 of IBC. Section 238 of the code reads, I'm just repeating, the provision of limitation shall, as far as may be, apply to the proceeding or appeals. That's what section 38 says. So what I'm trying to say in the end is various judgments have interpreted and decided the applicability of limitation in IBC proceeding, which we have seen, we have discussed case by case, specific provisions, specific issues, actions that we need to take under IBC, and applicability of provisions of Limitation Act. And finally, I would still say that the provision of Limitation Act are applicable to IBC proceeding as far as may be, that's the word, without frustrating the objectives of IBC. This is, I picked up this line from one of the Supreme Court's judgments, which clearly says it is applicable as far as may be, contextually, without frustrating the objectives of the IBC. I think that's all I have, and I'm open to now some discussion that.
Yes, Anand sir, this is Rajkumar Mehto. Now it is very well established with the judgment of all various honorable courts that based on the confirmation from the balance sheet, I mean, it could be concluded that debt exists and the default is there, and that fresh lease of life starts therefrom.
Yes,
but it has been like, a very cumbersome task to find it out from the filed balance sheet at the MCA portal, that many of the cases, the corporate debtor, they do not give the bifurcation of a list of creditors and debtors.
It's a very, very important and burning question. In fact, this is something which most of us who are compelled to file 19(2) would face, because the only kind of documents that you are able to lay your hands on is the publicly filed documents with the MCA. And neither in the XBLRA form or any other form, generally, you do not find detailed description, name, etc. of the parties. But few cases, if you go to MCA side, attachments are given, and it's easier for lenders to be found, because when you look at the current or non-current borrowings or liabilities, in that, not many cases, but some cases that I've come across where the name of the lender and amount due, etc. is mentioned. So Bank of Baroda, hypothecation, car loan, hypothecation, and the amount is mentioned. So that can be taken as an acknowledgement. But if there are 15 lenders, I don't think you'll find the bifurcation of the non-current liability, giving everybody's name, or even current liability, whichever, the loan, depending on term loan or whatever instrument that has been used. So that is a difficulty that we face. Until unless you are given the books of account where you are able to go back to the grouping and able to cull out, saying, yes, entry says here, this goes into the grouping of the balance sheet, and balance sheet is audited. So this is what my book of account entry says, and this is my balance sheet says. Now two are matched, so I can say the limitation period starts from here. The last, in absence of supporting accounting entries or books of account, it may be very difficult. Sir, I agree.
Sir, section 92, we can invoke once that CRP is admitted. Suppose section 9 application, somebody wants to initiate and wants to confirm, with the balance sheet. So how, you have your experience to, correlate these two before initiation stage?
See, I'll be very honest with you, sir, that most of the time, a bank or an operational creditor, when they file, many of you may be advising, but in my personal thing, I haven't, gone ahead and filed the application on behalf of a Section 9 guys. So in that, I have a shortcoming in that sense. However, you have to issue a notice and check with that. There is no other way I can think of other than the public documents, until unless some advocate is advising that you can compel him to submit his records in the court. Because once he submits records in the court, then one can go and make a prayer or mention while arguments that let him submit the breakup. What is the breakup of this? So that issue remains, sir. While filing, how to confirm, I mean, whatever is able to come to my mind, I'm able to speak that. Does that
Because
answer your question? Please.
yes, sir. But because many of the corporate data, they get a escape route through this only because it is very difficult to prove that whether they have acknowledged, even though like in a prima facie, it looks like, okay, if there is a default.
So let's it's an academic argument or discussion, not argument, discussion. Today, barring small things, from experience, the promoters, even though they lose, eventually they lose their company, except MSMEs, where they have a right to, 238 and 240. They can 248, they can, buy the company themselves. We haven't seen promoters' cooperation and they getting, any kind of a, in spite of NCLTs issuing non-bailable warrant against them, not many have been coming forward. So this is something which, to my mind, appears to be wait and watch kind of a this thing, until unless, like the fear of losing their companies have made the promoters now at the first instance of any stress, they go to the bank and try and work out their debt so that they don't lose the company. I think some time would happen when they start feeling the pinch. They would be very, very happy to. Of course, there could be certain historical reason to my mind. Many of them, once a company goes bad, they don't even bother to do anything. So they may genuinely not have, especially smaller ones, not the large ones. The smaller CDs, they kind of abandon compliance and accounting and other activities. What they keep with them is what is most important. The bank account, kitna paisa aa raha hai, kya hai, all that they keep in this thing. Audit karana hai, छोड़ो अभी तो company डूब रहा है, छोड़ दो. Default हो गया, bank ने surface कर रहा है. So they may not have it. All I'm saying is that they may genuinely not have it. So it becomes difficult to elicit that information. Even COC is very reluctant, even though the recent amendment says that COC members, if they have information, banks have lots of information in terms of stock reports, they do their inspections. A lot of things are available with them, projections. They're supposed to share, including any forensic audit that they have, they're supposed to share information. Banks are extremely reluctant. I don't know whatever for reason. So it's a challenge that we face. We'll have to either be very, very persistent in our chase and keep chasing the courts. Only when the courts start taking some penal action against them, which rarely happens, some information comes. Otherwise, that's a challenge that we face.
Thank you, sir.
Do we have any other question?
If anyone has any questions, we can take it up right now. So there are no questions in the chat box also. So,
I think it's good.
sir, I think your
Ah.
presentation was very clear and comprehensive.
Or my learned friends know the topic very well. Nevertheless, both ways good for me.
Yes, sir. So I think we can conclude the session then.
Oh, thank you so much. Thank you for a patient hearing and couple of questions that you raised. Thank you so much and have a nice day, whatever is left.
Thank you, sir. Thank you so
Thank you.
much for
Thank you.
taking the time out to address the participants and having this insightful session. It was very, very comprehensive and we learned a lot from it. It was very detailed. I am sure that is why we have such few questions, because everything was made clear during the presentation. So thank you very much, sir, for
Sir,
taking
are you
the
going
time.
to share the PPT?
So we'll share it.
Okay, thank you.
Thank you.
Thank you.
Thank you to all the participants for joining us, and thank you, Anand sir, for taking out the time to be here. Thank you very much.
Thank you. Thank you.
Thank you.